Well, hello. I assume I have already been introduced, but still, my name is Teresa Ribeiro. I come from Portugal, and it is my great pleasure to be part of this conference, albeit not in person, to discuss with you the impact of the new European governance on the Portuguese system. Before beginning, I would just like to take a brief moment to thank Marco Roca for this initiative, for steering this project, and also, of course, for inviting me to be part of it. Like I said, my presentation will concern the Portuguese panorama, and I would like to stress before I begin that the elements that I will be presenting you were compiled both by me and my colleague, Professor Catarina Carvalho, who is also writing the article with me. Well, concerning Portugal, from the several instruments comprised in the new EU economic governance, the most notorious one by Portuguese standards was, of course, the Memorandum of Understanding. In 2010, Portugal faced a severe economic and financial crisis that led our government to request financial aid from the European Commission, the European Central Bank, and the International Monetary Fund, the so-called Troika. This assistance was granted in 2011 under the terms of the European Financial Stabilization Mechanism, and in turn we had to adhere to a 3-year austerity plan laid out in the Memorandum of Understanding on Specific Economy Policy Conditionality. This memorandum entailed several measures and reforms, but I will of course focus on the ones concerning the labor market. Regarding this domain, the memorandum called for changes on a series of issues such as unemployment benefits, employment protection legislation, working time arrangements, wages, collective bargaining, or active labor market policies. And the clear aim of these changes was to reduce the costs related to employment contracts, to increase flexibility, and to relaunch collective bargaining under a new and more decentralized framework, since the strictness of the Portuguese labor legislation was deemed to be one of the main sources of our low levels of competitiveness, economic growth, and job creation. Many of these changes took place in the 2012 reform of the Portuguese Labor Code. And due to time constraints, I will focus on the ones that had a particular impact on the Portuguese system of industrial relations, sparkling a debate not only with the Constitutional Court, but also with European and international law. One of the measures contained on the memorandum concerned our minimum wage, since the memorandum demanded a wage moderation policy in order to develop both the national competitiveness and productivity in order to and also to reduce the unemployment rate. To this effect, the government decided to link the increase of the minimum wage to economic and labor market developments, and also to an agreement in the context of the review of the financial assistance program. As a result, minimum wage was frozen at €485 from 2011 until 2014. The minimum wage was only updated in 2014, the year of parliamentary elections, to €505, and further adjustments were also made in the following years, but this time by the hand of the left-wing government that came out of 2015 elections, and that was also later on re-elected in 2019. This evolution was not endorsed by the European Union, since the country-specific recommendations from 2014 until 2017 kept stating that minimum wage developments should be consistent with the objectives of promoting employment and competitiveness across sectors, which meant aligning them with productivity. Nevertheless, to this date, the Portuguese minimum salary is still quite low, particularly when comparing with other member states. And study shows that the adjustment program had a considerable impact in the equality and poverty levels felt in Portugal. Between 2009 and 2014, the poverty rate increased 6.3%, and the gap between the richest and the poorest has widened. On the other hand, the situation was also censured by the ILO because the lack of updates on the minimum wage meant disrespecting the previous social dialogue agreements on minimum wage evolution. The ILO also stressed that minimum wages should be determined taking into account not only economic factors but also the needs of the workers and their families, and they should also be regularly adapted and adjusted. In turn, the European Committee of Social Rights also stated that during this period, Portugal was in breach of Article 4, Paragraph 1 of the revised European Social Charter, since the minimum wage was manifestly unfair and did not ensure a decent standard of living. The public sector was also quite affected, since there was not only a freeze to new admissions to public administration, but also their salaries were cut, promotions were constrained, and the annual holiday and Christmas allowances were cut off. In 2011, the budget law determined a number of progressive cuts to the salaries of the public sector above 1,500 euros. The Constitutional Court enabled these cuts, subscribing to the argument of economic crisis and considering them to be justified in the scenario that existed at the time. In 2012, the budget law maintained these cuts and also reduced or suspended, according to the situation, the annual holiday and Christmas allowances. This time, the Portuguese Constitutional Court was less tolerant towards the crisis argument, and it also felt that there was an unequal and disproportionate sacrifice on public servants by comparison with other employees and citizens. For this reason, the suspension of the annual holiday and Christmas allowances was considered unconstitutional. However, the court decided to exceptionally allow the application of these measures, since the budget had been in execution for half a year, and also in order not to jeopardize the Troika's financing. In 2013, the budget law contained similar provisions, which were again considered unconstitutional, and this time this decision had full effect. Finally, in 2014, the budget law intensified the austerity measures, amplifying the number of affected employees by lowering the threshold, and also by increasing the progressive rates of pay cuts. Once again, the court considered these measures to be unconstitutional based on the principle of equality. Moving on now to the changes to the new rules on working time, there was an increase on the number of working hours per week for the employees of the public sector, from 35 to 40 hours per week without further pay. This change was unsuccessfully challenged before the Constitutional Court. Regarding the private sector, and following the memorandum's demand for increased flexibility concerning working time, there was the introduction of an individual time bank. Well, time banks basically are a way to demand more work from employees without the costs associated with overtime. Initially, they could only be enacted through collective agreements. But in 2012, it also became possible to introduce them through individual negotiation between the employers and each of their employees. Furthermore, it also became possible to apply a group time bank, which basically allows the application of a time bank enacted by collective agreement to all the employees of a team, economic unit, or section, when at least 60% of the employees of this unit, economic unit, or section are already covered by such collective agreements. As a result, those collective agreements will have a partial and impious erga omnes effect, when in Portugal, the rule for the application of collective agreements is the principle of affiliation. At first, this group time bank was also applicable to individual time banks, but since the latter were revoked in 2019, this possibility became now restricted to time banks enacted through collective agreement. The group time bank drew a lot of controversy, particularly when supported on collective agreements, since it seems, and in my opinion it does, encroach on the right to freedom of association, as well as onto the right of conciliation between personal and professional lives, and so on. However, the Constitutional Court declined to declare the unconstitutionality of the scheme. Nevertheless, and according to the ILO, the time bank mechanism in all its formats seems to encroach on ILO Convention number 1, and according to the European Committee of Social Rights, it may also breach Article 4, Paragraph 2 of the revised European Convention of the revised European Social Charter. Although the committee has asked for more information from the Portuguese government. Even though the previously analyzed working time arrangements reduced the need for overtime work, the 2012 labor reform also halved the increases in hourly pay for overtime work and abolished as well the right to compensatory rest for overtime work performed in regular working days, complementary weekly rest days, or public holidays. With the intention of bringing immediately up to speed previous employment contracts and collective agreements on this issue, the clauses of these instruments, which conceded such compensatory rest, were declared null and void, while the clauses enshrining a more favorable payment for overtime work were suspended by the new legislation, which, I should stress, was not a requirement of the memorandum. The Constitutional Court analyzed the situation vis-à-vis the clauses of collective agreements and considered that their nullification was unconstitutional. In fact, since this is an issue usually open to collective bargaining, and since new agreements could provide for this compensatory rest, this measure was deemed to be disproportionate and to encroach on the right to collective bargaining. However, the court validated the aforementioned suspension since it considered this to be a temporary, appropriate, necessary and balanced measure, taking into account the goals set by the memorandum and also the need to increase the competitiveness of the national economy in a difficult situation. Another measure implemented following the memorandum was the reduction of severance payments in case of lawful dismissal. This was progressively achieved and, as a result, currently in this situation, employees are entitled to 12 days of base salary and seniority payments per full year of tenure. Like it happened concerning working time arrangements, it was also determined that the clauses of previous collective agreements and employment contracts enshrining better conditions would be null and void. And this time, the Constitutional Court considered this measure to be compatible with the Constitution, since dismissals are, as a rule, an issue in which collective bargaining does not have a lot of leeway. However, the elimination of the employer's obligation to offer an available and suitable position to the affected employees as an alternative to dismissal, which was also demanded by the memorandum, was considered to be unconstitutional and therefore was reinstated, as was the abolishment of the least seniority rule when selecting the employees to be dismissed, since the court considered that it was being replaced by new criteria that were too vague to be judicially controlled. Later on, the government created new criteria, the least seniority being the last of it. Finally, and since time is running out, and I don't want you guys to close the video before I finish speaking, I will now address the changes to collective bargaining. It should be noted that several important changes to our collective bargaining regime with the intention of its flexibilization had already happened before the crisis, such as the erosion of the principle of more favorability in relation between statutes and collective agreements, or the introduction of the mechanism of expiry or expiration of collective agreements, both dated from 2003. However, during the crisis, collective bargaining suffered a major blow, mostly due to the measures imposed in the memorandum, particularly the demands it made regarding the administrative extension of collective agreements. In fact, in Portugal, like I said before, collective agreements are applicable under the rule of affiliation. This means that a collective agreement is only applicable to employees that are affiliated to the trade union who signed it and to the employers who also did it. However, in our regime, union density is low. Taking these elements into account, collective bargaining coverage should be very low. But that is not the case, since in the private sector, collective bargaining coverage is about 90%. This number is achieved precisely through the administrative extension of collective agreements. Before the crisis, the Minister of Labour could select any collective agreement for this effect, but intending to promote a greater competitiveness from the Portuguese undertakings, the memorandum imposed the introduction of a number of criteria for for this effect. The consequences were immediate. The number of administrative extensions dropped, as did the coverage of new agreements. And furthermore, there was also a decrease in the number of new collective agreements. In fact, employers were no longer interested in entering into these agreements when there were no guarantees that they would be afterwards extended to their competitors. This situation led to severe criticism from trade unions and employers' associations alike, but it was only surpassed in 2017 when the previous criteria were eliminated and substituted for new and much more flexible rules. Another demand of the memorandum was the shortening of deadlines related to the expiry of collective agreements, which was achieved in 2014, following the country-specific recommendation that reaffirmed the need to revise this regime. This same country-specific recommendation also added the request to open the possibility of mutually agreed firm-level temporary suspension of collective agreements, which was accomplished also in 2014 with the enshrinement of such a regime. To conclude, the reforms imposed by the Memorandum of Understanding on the Portuguese labor regime resulted in lower earnings to a significant proportion of employees, extended working time periods without additional pay, more flexible working time schemes, easier and lower cost dismissals, and also a severe erosion of collective bargaining. The unemployment rate only started to decline after the reversion of some of the austerity measures by the new left-wing government elected in 2015. But the truth is that it is not clear whether this decline is an outcome of the austerity measures, of the reversion of such measures, or even if it is just an effect of other cyclical changes. What should be noted is that this recovery of employment is being accompanied by an increase in the instability of contractual ties, which goes hand in hand with the stagnation of wages. In fact, labor market segmentation has been a long-standing feature of the Portuguese labor market, and despite the considerable reduction in levels of employment protection brought by the austerity measures, this rate has not subsided. What resulted of the austerity measures was the worsening of the quality and stability standards for future working generations, and also the expansion of inequalities. Thank you very much for your attention. I will be, technical conditions permitting it, available to answer any questions you might now have. Thank you.